Good afternoon, everyone. My name is Garrett Schmidt. I am the managing editor for ACOexhibithall.com, and I'd like to welcome you all today to today's webinar entitled Leveraging ACO Waivers, an Investment Opportunity for Physician-Led ACOs, and this should be a really good one. A few items of note before we get started here. First of all of you who joined as attendees have joined in attendee-only mode, so this is a listen-only mode, so you don't need to worry about muting your mic. That'll be done for you. Secondly, I'd like to inform you all that the webinar is being recorded, so you will have the opportunity to rewatch the session and share it with colleagues after its conclusion. And a link to the recording will be emailed to all the registrants following the presentation. So even those who weren't able to attend, if they registered, they should get a link to the recording. And of course, it'll also be available in our archive library at ACOexhibithall.com. If you search for webinars, you should be able to find it there. All right, finally, during the webinar today, you will be able to submit questions to our presenters anytime during the presentation. On the little side panel there that you have, the little admin panel, if it's hidden, you click the little orange arrow and it'll open it back up. And there's an area for questions, and then you just put it in there, and then we'll be able to field those at the Q&A time. If we don't get to yours today, these are being recorded as well, and so our presenters will be able to get back to you via email after the presentation. All right, well, without further ado, our presenters today are John Kirstner, partner with Jones Day, and Gary Thompson, who is the CEO of Synchrony Health. And wanted to welcome you guys today. So welcome, guys.
Well, thanks, Garrett. Our topic today is ACO waivers. And I think most people in the ACO space are familiar with the SNF and the telehealth waivers. And if you thought that's what this webinar was about, well, I apologize. Our discussion today has nothing to do with those. But today we'll be talking about what I think is a much more intriguing and powerful concept. Now, if you're in healthcare, and we all are, you're no doubt familiar with the Stark Law and the Anti-Kickback Statute. But what most people don't realize is that within an ACO, the Stark Law and the Anti-Kickback Statute can be waived. Well, CMS recognized from the outset that for an ACO to be successful, you need close collaboration between providers all throughout the delivery system. And these laws and statutes can greatly limit those collaborations. These waivers allow providers within the ACO to enter into relationships with other providers and with each other that would otherwise be barred by the restrictions of Stark and Anti-Kickback. I'm Gary Thompson from Synchrony Health. I spent the last 25 years in the risk-bearing healthcare space on both the provider and the payer sides. I founded the country's first ACO enablement company back in 2010. I've spent the last couple of years working on a new ACO business model based on maximizing the opportunities presented by these waivers. As Garrett mentioned, I'm joined today by John Kirstner, partner at Jones Day, which, if you're not familiar, Jones Day is the world's largest law firm. And John spent his entire career advising healthcare organizations in all different kinds of transactions, and he's got very deep experience in the value-based healthcare world. John is Jones Day's one of their leading attorneys when it comes to the ACO waivers, but I can tell you, having done this for a while, I've not found anyone who understands these waivers like John does. We've worked together in the application of the waivers to maximize the chances of success for physician-led ACOs. And as you know, with the challenges being faced by independent providers, well, these waivers can provide a path to not only survive, but actually prosper in this new value-based healthcare world. So with that, I'll introduce John.
Thank you, Gary, very much. Hey, what we're going to discuss today are a series of key topics around the waivers. First, I'm going to try and, in simple, plain English, describe what these waivers are and how best to use them. We're going to then get into a legal deep dive, and we will talk about fraud and abuse waivers that include the participation waiver and the waiver of the civil monetary penalties law. We're going to get into the logic behind these waivers. Why has CMS put them into place? Why do they make sense? Why are these really good things in a value-based world? Why are they, in fact, I think from Gary and my perspective, difference makers. Difference makers in terms of your ability to really achieve shared savings with the government or not. We're going to talk about how we stay compliant because we don't want to run with scissors. And we are going to talk also about how to avoid hard lessons and really get into what are the most effective uses of the waivers. Finally, we're going to talk about some key limitations, some fallback strategies, some do's and don'ts, because the waivers are there to advance a triple aim. This isn't you can do everything that anyone could do in the world. So that's sort of an overview of what we're going to hit and what the agenda looks like today.
So let's start off talking about some of the basics of the waivers, and then we'll get into a few examples before John dives into the legalese behind it. So as you know, Stark and anti-kickback were historically the government's way of limiting these kind of undesirable relationships that might drive up healthcare costs through overutilization. Now, if you think about an ACO and the underlying incentives, well, preventing overutilization is job one, right? You can't really control unit cost, but you can certainly control utilization. So when you think about the incentives of the ACO vis-a-vis Stark and anti-kickback, well, it becomes pretty clear that Stark and anti-kickback are actually redundant, and in a lot of ways, they create unnecessary barriers. Well, when CMS created the Shared Savings Program, they decided to allow ACOs to implement these self-made exceptions or waivers of Stark and anti-kickback. And John will get into the details of the self-made concept a bit later because it's very intriguing. Now, these waivers, they provide freedom for providers to work together to build the kind of infrastructure that an ACO needs, particularly the care coordination processes. And as we all know, good care coordination simply makes healthcare work better. Well, these waivers can be real keys for the ACO to create the type of virtual clinical integration necessary to be successful. So again, let's talk about a couple of examples. So let's start with startup and operational funding. So let's say there's a group of independent PCPs who want to set up and run an ACO. Now, as we all know, in order to be successful, it takes infrastructure, and infrastructure takes money. So what are their options? Well, the PCPs can try to fund it themselves, but this takes a lot of money and they simply don't have that kind of money. Or they can go to the private equity market, but unfortunately this winds up meaning they give up a big chunk of their financial opportunity. Well, CMS realized these challenges and they created the waivers as an important alternative. See, there are natural funding sources in the marketplace for ACOs, and these natural funding sources are the downstream providers who are reliant on independent physicians for their livelihood, right? Well, through the use of the waivers, CMS paved the way for these other entities to contribute working capital to help fund the ACO's operations and create the kind of operational alignment that will greatly enhance their chances of success in lowering costs and improving outcomes. So for the strategic partners, obviously the first order of business is to work with the ACO to improve costs and improve quality. But if they can assist the ACO with operational funding and building out the care coordination processes, well, these can be the kind of the missing ingredients for the ACO's success. And as I said, over the past couple of years, John and I have worked together to structure these kinds of relationships to provide the critical funding that a lot of the physician-led ACOs are lacking. Well, let's talk about something that everybody's dealing with today. As we know, CMS is pushing every ACO down the path of taking on risk. There are ways to minimize the dollar amount of the risk, but it's still a significant amount of money. Unfortunately, a lot of ACOs, particularly the physician-led ACOs, will simply drop out of the program, and that's both unfortunate and unnecessary. Now, when we look at the three repayment mechanisms, well, they can be somewhat challenging for physician-led ACOs. So, funding an escrow account or securing a line of credit when you've got, dozens of practices, well, at a minimum, that's a logistical nightmare. Well, a surety bond offers advantages in that it's about the same price as a line of credit, but it doesn't tie up anyone's credit, right? Well, having a track record of success certainly helps when you're acquiring a surety bond. Now, reinsurance can be purchased to offset the downside risk, but regardless of the mechanism, the waivers can be leveraged in much the same way as in our first example. And in this scenario, if you think about it, the waivers create opportunities for everyone affiliated with the ACO to share in the risk, and then not just the physicians who make up the ACO. And in my mind, this was a key reason that CMS created the waivers. So these are a couple of real world examples that are very practical in nature, but at the same time, the use doesn't stop there. And let's look at a really exciting way to apply the waivers. The waivers actually allow an ACO to create ancillary service lines that are owned by the ACO and therefore by its physicians. Now, as you know, this is one of the reasons why a lot of physicians choose to belong to some of these mega groups. Well, these waivers help level the playing field for the smaller independents. So in this example, an ACO's imaging costs are too high, and they realize that taking advantage of the huge reimbursement differential between hospitals and freestanding facilities is a great way to reduce healthcare costs. And what's cool about this is that the profits from this cost-saving initiative can inure to the benefit of the ACO and its physicians. Now, historically, the single TIN approach allowed physicians to benefit from ancillary revenue streams. But now, through the waivers, these services can be delivered through the joint participation of the ACO's providers. And moreover, the waivers can actually apply to any kind of healthcare service. And your strategic partners, like your specialists, can actually refer to this new service. And what this does is it actually helps reduce healthcare costs even further and enhances the new center's profitability. And let's face it, there's nothing wrong with making a profit by reducing overall healthcare costs. So while all of this sounds great from a business perspective, and as I said, John and I have done these things, this at its core is a legal issue, and this is where I turn things over to John.
Thank you, Gary, very much. Well, we're going to start by sort of hitting the basics before we get into the waiver rules themselves. What are we really talking about here? Well, we're talking about the classic healthcare regulatory laws that all of us in healthcare have been working with for the last 30 plus years or more. And the two big statutes are the Anti-Kickback Statute and the federal Stark Law. The Anti-Kickback Statute is a criminal statute. It has also significant civil penalties attached to it. But you can go to jail for violating the Anti-Kickback Statute, and folks in healthcare have, right? The Stark Law is not a criminal law, it's a civil law, but there are steep penalties for violating the Stark Law, and Stark Law is a strict liability statute. It's sort of like if you run a stop sign or run a red light, you have violated the law. There is no intent necessary. You've just simply violated the law. That's what happens when you run afoul of the Stark Law. These two laws have caused all of us in healthcare to do joint ventures, to do contracts, to do any sort of business arrangement that involves healthcare providers in very prescriptive, very limited sorts of ways. You do it a certain way or you just can't do it. That's the Stark Law. And with the Anti-Kickback Statute, you fit within a safe harbor, or if you're outside a safe harbor, it's got to be a very low risk kind of scenario given the criminal penalties. Well, anyways, this is where the waivers can really come into play and help an accountable care organization. There are three key waivers that matter for our purposes. The shared savings distribution waiver that allows us to distribute, right, shared savings when we get them from the government to our ACO participants. The patient incentive waiver, which is very powerful, and that allows us to waive the civil monetary penalties law to really promote, right, patient engagement with specific positive sorts of treatments and preventive treatment options, and the participation waiver. The participation waiver is open to any ACO that participates in the program with the federal government, and it allows us to waive the Stark Law and the Anti-Kickback Statute if we're doing something that is pro AAA. And then if we continue on, then these waivers are broad, okay? From a characteristic perspective, many arrangements that one cannot do or that would present a material risk under the Stark Law, the Anti-Kickback Statute, or the Civil Monetary Penalties Law become doable if you're in an ACO environment and the ACO has approved of the particular arrangement that is the topic of discussion. The waivers extend to any potential arrangement that involves an ACO or that involves one or more of the ACO participants or one of the ACO providers or suppliers, okay? And that means it's a very broad, sort of application. These waivers don't merely only work for the ACO itself. It can work for a deal that involves ACO participants but doesn't involve the ACO, for example, on an equity basis. You can do that. And so it's very nice in terms of how broad the scope of this can be. The participation waivers, if we're going to waive the Stark Law or the Anti-Kickback Statute, we need public disclosure, and we'll get to what that entails in a little bit. And these things are self-executing. We do not have to go to the government like you have to go to the government and ask for an advisory opinion of the Anti-Kickback Statute or the Stark Law. So this is a much easier process to get through, a much less expensive, a much less time-consuming process. So that's a real positive of these waivers. Look, in order to have a participation waiver go into effect, the governing body, sort of a $5 phrase for, I suppose, the ACO's board, okay? The board of the ACO needs to determine that the arrangement's reasonably related to the triple aim purposes of the Pathways to Success program. Now, CMS has given us a lot of guidance, okay, with regard to the waivers, but there is no one size fits all on how to make this determination. And CMS has said in its guidance, they get that there are going to be ACOs of very different sizes. There are going to be ACOs that are owned by hospitals. There are going to be ACOs that are owned by large multi-specialty group practices. There are going to be ACOs that are owned by a series of small, independent primary care practices. And so that difference in structure is going to mean that the determination is different for everyone. Now, with that said, it's got to be pro triple aim. And as you see in the second series of bullets on this slide, a couple of things that you just can't do. There is no such thing as a waiver that would involve a pay-to-play referral arrangement. There is still no paying for referrals. The government is very blunt about that in the guidance. Another example, you can't have a medical directorship or some other sort of arrangement where doctors get paid for doing nothing, right? That hasn't been allowed under the current paradigm, and it is not allowable under the waiver arrangements either. Free gifts are not allowed. You cannot just simply make a free payment to a lab company or a home health provider or vice versa. So just freebies are not allowed. Now, assuming that we've got one of those good examples that Gary gave us before, assuming that our board of our ACO has considered the pros and cons of the waiver and has gone ahead and said, yep, you know what, this one should work. For the participation waiver, we're going to have to be transparent. The government says, be transparent when you put a waiver in place and put a description of the waiver on your ACO's website for all to see, okay? Now, the disclosure is not onerous, and we don't have to disclose the guts of the financial or economic terms, okay? In other words, we don't have to give away the secret sauce in the public disclosure requirements. But if we're doing a joint venture between the ACO and a home health company, we do have to say that what we've done is use the participation agreement for a joint venture that involves a home health company and the ACO and perhaps some ACO participants. We have to say that that's what's going on. We don't need to say if the ACO is a 50% owner. We don't need to say the guts of the economic terms, but we do have to give enough there so that either the government or a third party can look and can see what's going on. This public disclosure has to occur within 60 days of the date of the arrangement, okay? In other words, we don't get our waiver protection until we get this public disclosure up on our website. Gary, back to you.
All right, thanks, John. So in many respects, these waivers have been a pretty well kept secret, right? But as John said, the use of the waivers has to be publicly disclosed. So we know exactly the extent to which they've been applied. We've looked at every ACO's website in the country, and there are only a handful that are actually making any mention of the use of these waivers. Now, part of this, I'm sure, is just simple lack of awareness, because CMS hasn't really broadcast these opportunities loud and clear. But I also think part of it is that people just don't trust the notion that CMS would undo 35 years of regulation. I get that reaction a lot when talking about these waivers, that it's just simply makes no sense because CMS has tied everybody's hands for years. Now, while CMS won't explicitly say it, there's a very solid rationale for why they spent months and months working with the DOJ and FTC and the IRS in creating these waivers. And in my mind, a lot of it gets to the simple reality of what healthcare is today, and that's kind of a two-party system where you've got the big integrated healthcare systems on one side, and on the other, it's the independents. And I think the independents are who CMS is really counting on to make value-based healthcare work. You know, systems have been free to just kind of buy their way into clinical integration over the years, and so they have tremendous advantages in this new world. Well, CMS understood that it kind of needs to level the playing field in allowing these basic business relationships to exist among independents in order for this new model of healthcare to work. Now, at its core, I think the most important people in this equation are the independent PCPs, and I think these are the folks that CMS really thought long and hard about when they created these waivers. Well, first of all, you know, it's the population of patients served by the ACO's PCPs that defines the ACO. So it's primary care centric. Unfortunately, these same folks don't have the resources necessary to make the investment. So it's pretty clear to me, at least, that the waivers were created to help address this by allowing downstream providers to become preferred providers and invest in the ACO. Just makes all the sense in the world. Now, I also believe that CMS designed the Shared Savings Program and the waivers to help address a big problem in this country, and that is simply that independent primary care needs to be much more economically viable as a profession. And between the bonus opportunities of MSSP and the opportunity to participate in ancillary service lines, there's a lot to be gained by PCPs. Now, this is all good stuff, but again, you have to be considerate in both the what and the how of applying these waivers. John?
As we get into these waivers, one of the things that I think is probably on most of your minds, and it's on most of our clients' minds, is, okay, what happens if, you know, the waivers go away? What is our fallback strategy? And it's a great thing to keep in mind for every ACO board, for every ACO participant that's part of a waiver. You have to be thinking, as you get into them, what is going to happen if the waiver disappears. Now, why would the waiver disappear? The waiver could disappear for a couple of different reasons. First of all, the waivers are allowable because the ACO has a contract with the government to participate in the program. The government could take that contract away. The government could cause the program to end. Now, it doesn't show any signs of doing that, but still, that program is part of healthcare reform, and it could end at some point in the future. The government could take a contract away from an ACO if it felt that the ACO was not doing enough to promote shared savings and to promote the AAA. An ACO itself might feel the need to get out of the program. There could be serious losses on downside risk causing an ACO to want to abandon participation in the program. If that happens, the waivers for that ACO would go away. There's another thing here. Even if those sort of draconian events don't happen, those sort of Game of Thrones events don't happen, the fact is that the board of every ACO has a duty to look and see how the waivers are doing, these waivered arrangements are doing. And if the ACO board says, we thought this was going to be a great use of the waiver, but shoot, it just hasn't worked at all, right? The particular thing we've done. We thought that distributing the electronic health records was going to be great. The fact is it's not doing its job. The board of that ACO has the ability to take a waiver away and the use of the waiver away as well. So you have to have a fallback strategy in place. What is part of that fallback strategy? First of all, you want to have what you're doing in writing, and you want to have a written agreement on what the fallback strategy is. So if we've got, for example, a joint venture relationship that we know can be reformatted to be consistent with the Stark Law and the Anti-Kickback Statute, let's put that in writing that says that's what we're going to do as part of the fallback process. If we know we need to get out of a particular joint venture and get into, let's say, a services contract to make it compliant with Stark and Anti-Kickback, let's put that in writing in as what we're going to do. Let's be transparent and let's be forward thinking and let's really have a good plan so that we know what happens in sort of that situation where we don't have a waiver any longer. Fair market value, of course, is always going to be important. And as I've said, comply with the Stark Law exceptions and the Anti-Kickback Statute safe harbors if we have to get away from the use of the waiver. Gary?
So there are a lot of potential pitfalls with these waivers, and a lot of them are avoidable. Number one, make sure that it's actually set up to lower healthcare costs. If it's not designed to save CMS money, don't waste your time. There are just too many other opportunities to leverage the waivers in a way that will reduce healthcare costs. Secondly, make sure that it improves the care coordination processes. This will help address the other two legs of the triple aim. Next, start with pre-existing relationships. These arrangements work better when there's already a basis of trust. Make sure that you've got metrics and targets established up front that address the three-part aim. Now, this is important from a CMS use of the waiver perspective, but it's also really important to make sure that what you're entering into is a good investment for that partner, right? Got to make sure that you've sized the relationships and the contributions appropriately. And then lastly, work the relationship. Work together to build and staff better care coordination processes. Bring on staff to engage your providers and educate them about the network and the processes. If you do this, it creates wins for everyone. But unfortunately, this is the part that sometimes get lost. So these are really important relationships, and doing the necessary diligence up front is obviously important for making the case for the board's determination. But I think more importantly, it's important from a business perspective to ensure that it works for the ACO, but then it also works for the partners. John?
Some important cautions, and we've had one or two of these already, but these are really key things. ACOs and their waivers are wonderful things. It's an opportunity to share savings with the government. It's an opportunity to figure out how to work in a value-based world instead of a volume-based world. But look, we can only, with our ACO waivers that have been given to us by the government to date, waive certain laws. The Stark Law, the Anti-Kickback Statute, the Civil Monetary Penalties Law, okay, with these fraud and abuse waivers. In other words, there are all sorts of other laws that we cannot waive using the waivers. What are some examples of those? Well, for example, conditions of participation to participate in the Medicare program, right? Medicare reimbursement rules, right? So that, there are all sorts of requirements that one would love to be able to do away with in a value-based world, but that just aren't going anywhere, at least not with these fraud and abuse waivers, because they only have a certain scope, basically. Also, they only apply during the participation in the MSSP program. In other words, if you're working on something and you don't have an ACO, but you've got, a bundling program going with the government, VPCI advanced, that's not good enough. You can't use these ACO waivers if you don't have an MSSP ACO, even if you're working in some other area of value-based care with the government. You need an ACO. As I said before, and I'll say it every day when I talk to my clients on it, we can't pay for referrals, right? There is no pay for play. The government's been clear on that. And I think we all understand and should understand that we just simply can't hand dollars to doctors so that referrals flow one way or the other. It just can't be that simple. Now, comply, comply, comply. Make sure your compliance officer of your ACO understands which waivers are in place. Make sure that your ACO has in fact complied with the requirements. That means having a written presentation that goes to the board of the ACO. That means resolutions that the board of the ACO sign off on. That means having the public disclosure. If we don't do that in our ACO, we're putting ourselves into harm's way, right, with the government. CMS and the OIG, they're joint authors of these waivers, and they have said loud and clear that they can and will audit ACOs that are using the waivers if they feel there's an issue. There have been some audits to date. Overall, though, I think we can see that CMS and OIG are pretty positive about the uses of the waivers. After all, the first waiver guidance came out all the way back in 2011. And in 2015, the waiver guidance was finalized. And in 2018, as we all know, the Pathways to Success regulations completely overhauled the ACO program. And each time these really big events happened, the government continued and continued onward with the ACO waivers. So one can say that the government believes in the ACO waiver strategy, but you better comply with their requirements. Lastly, scrambling's a bad thing unless you're a quarterback in the NFL. We want to know what the fallback strategy is. We want it, as I said, in writing. We want to be as prepared as we can be, right? The Boy Scouts, that's what we should want with our contracts here. And that's an extra step that doesn't necessarily, and of course wouldn't happen if we're abiding by Stark and Anti-Kickback. You don't have to worry about that. But here you want to have that fallback strategy well known. Folks, it was great talking with you folks on these topics, and Gary and I stand open at this point for questions, and throw it back to the moderators.
All right. Well, thank you, guys. We do have a few questions that have come through, so we'll just kind of go through these one at a time. And if you do want to continue to ask a question, you can do that on the panel, again, on the side. And Gary, I think we lost your screen there.
Yeah, I switched the presenter to you, Garrett.
Oh, okay.
Sorry about that.
No, that's all right. Let's see here. Well, we'll just go through these questions for right now, and then I'll get that set up here. First question is, do the partner contributions come with a share of the savings or an equity stake?
I'll take that one. It certainly can. I'll give you my point of view on this. Number one, any prudent healthcare provider from a business perspective is going to make an investment that is going to not be a bad investment. This isn't charity, right? At the same time, by becoming a preferred provider to an ACO, you're in a position to greatly increase your share of the service base for that population. And while we're not talking about paying for referrals, it's certainly understood by everybody that getting an increased share of the referral stream is going to happen, and that's not a bad thing as long as everybody's working towards the 3-Part A. So the partner is probably going to be in a much more prosperous position naturally. So the notion of giving them a share of the shared savings, well, that's, yeah, okay, that makes sense, but at the same time, is it really necessary, given that they're going to be in a better position if the deal's structured correctly? On the equity side, I'm averse to that for one simple reason. You got to make sure these relationships are going to work over the long haul, and you got to go into them with your eyes wide open. If you lock somebody into an equity stake, you might be hooking your saddle to a horse that you can't ride over the long term, and that's not a good position to be in. So.
Yeah, I'd just add in on that from the standpoint of the waivers, it's possible to see them happen either way, through shared savings or through an equity payment like a joint venture or something like that, as opposed to ownership in the ACO. So each of those are possible to do consistent with the waivers. And I do agree with Gary that it is not paying for referrals to enter into a preferred a provider relationship with, say, one or a series of home health companies or skilled nursing facilities or hospices or other types of providers, right? The goal is to align yourself and your ACO with the best, right? And with those that get it from a care coordination standpoint. And I think Gary's right. Those best in class providers working with the ACO likely will see enhanced referrals, but that isn't paying for referrals. That's care coordination with organizations that get it from a value standpoint.
Okay, great. Next question is, can you discuss the state versus the federal supremacy when it comes to legal enforcement? Many states have their own mini Stark and or mini ACOs.
Yeah, that's a great question posed. The waivers themselves apply to the federal Stark law, the federal Anti-Kickback Statute, and the Civil Monetary Penalties Act. They do not apply directly to state Stark or anti-kickback analogs. Now, with that said, what that means is you do need to think about the state that you're in and what its laws say with regard to fraud and abuse. But look, many states, the vast majority of states in the nation, in fact, have either very short form laws, very limited laws that relate to these sorts of fraud and abuse issues. Many times those laws will say, if you're compliant with the federal law, you're compliant with state law, okay? So in most situations, first of all, in every situation you have to do the analysis, but in most situations you find yourself, if the waiver's in place, you're gonna be in a compliant scenario. Look, you do have to do the analysis. There are some states that are very aggressive with their fraud and abuse laws, and they're, folks that I think everyone's aware of. I don't think it's going to surprise anyone if I rattle off states, like California, New York State, New Jersey, Florida, right, are just 4 really good examples of states with strong state level, fraud and abuse laws. And so that doesn't mean you can't do your waiver. It just means you have to understand what you're doing and how you're doing it, and how it can fit in with the state law as well.
Okay, great. Next question is, so commercial ACOs are not eligible for ACO waivers?
Well, that's another great question. This is Kersner. Yeah, so it isn't quite that easy, but let's put it this way. First of all, in order to put a waiver in place, your ACO has to be an MSSP, ACO. The only ACOs that are allowed to waive the federal healthcare regulatory laws are MSSP ACOs. Now, if an MSSP ACO waives an arrangement, and that arrangement implicates both Medicare beneficiaries and commercial beneficiaries, it is possible for that waiver to be broad enough to include the commercial beneficiaries as well. What's an example of that? Well, for example, we at Jones Day have put into place something called hospital quality and efficiency programs. That's when a hospital will work with an accountable care organization and will say, hey, what we'd really like you to see is you folks working collectively to make the entire hospital environment a more competitive place, a more efficient place. That's going to impact on Medicare beneficiaries. That's going to impact on fee-for-service beneficiaries. Because it impacts on the Medicare beneficiaries, the waiver can go into place, and there is guidance right in the waiver guidance language promulgated by CMS and OIG that says that that can be broad enough to take into account those commercial beneficiaries as well. But your questioner is right on target. You have to start with an MSSP ACO. If all you have is a commercial ACO, sometimes they're called clinically integrated networks, whatever you want to call it though, if you don't have your MSSP ACO, you're not going to be able to get that waiver put in place.
Got it. Okay, and last question is, could Mr. Kirshner please give us some real-world examples of waivers that he has seen through the process, and also any specifics on the joint venture waivers would be great too.
You know, the folks are picking on me right now.
I know, right?
But absolutely. Let me give some examples. And I'm going to shy away from examples that involve hospital, led ACOs. Let's put this in the physician context. I think that's who we have on the phone today. Seen really interesting examples involving lab, for example. I've seen waivers that involve a joint venture where the ACO had purchased lab equipment and then licensed it back to a group practice so that the group practice could bill the government. I've seen in that sort of strategy independent doctors, independent PCPs not affiliated with the group practice be able to participate in the profits. That's something that is just not allowed under the Stark law, right? Under the Stark law, you'd want to and have to do that as an in-office ancillary service, okay? And you'd need a group practice to do that. But using the waiver, you don't need to do in-office ancillary and you don't need a group practice. So you can have multiple group practices own your lab. I've seen I've seen a lot of examples of, I'll call them care coordination arrangements. They're really sort of management agreements, but the idea is that a hospice or a dialysis center or a home health agency or a SNF or a string of those organizations contracts with the physician-led ACO for the physician-led ACO to provide care coordination services to those organizations. The whole idea is that if those organizations can get the patients healthier, faster into the lowest, level of care, get them out of higher levels of care, get them out of the hospital, get them out of the SNF, get them home, and avoid readmits, we're going to save the government money. If we're saving the government money, our physician-led ACO is going to make money eventually, right, from the shared savings, and that is, going to allow us to support these kinds of arrangements. Usually what happens is the home health company or the hospice company is paying for those care coordination services. And I go back to, that's not a payment for a referral. They are paying. They are getting the care coordination services. They're likely to get more referrals as a result of it. But we're going to have the metrics in place that Gary talked about. It's going to cause us to work only with superior ancillary providers. That's going to cause our ACO to have a better savings in the long run and a better shot at a shared savings payment. Anyways, those are a couple of examples, and we could go on with others, but at least that shows some examples out there where doctors, primary care doctors, are getting very innovative with their waivers and looking to really try and attack where savings can be found.
Yeah, and just to pile on there, part and parcel to these relationships is, you are, as a preferred provider and a strategic partner to the ACO, there's no question that you're going to be getting more patients out of our population. But the simple understanding is, number one, you're going to be doing it in a way that you're going to be getting less revenue per patient, okay? Number two, and this is where the metrics become really, really important, is, we appreciate the funding contribution, but at the same time, we're going to hold you to certain key metrics that reflect best practice for your particular service. So if it's a SNF, obviously you look at length of stay, but we also look at things like rehospitalization rates. So we want to make sure that these deals work over the long haul.
Great. Well, all right. Well, thank you, gentlemen, again, for those questions that you answered, and for anyone else that has questions that they would like to ask these guys, their contact information is here on the screen. And I also want to let everyone know this is actually a Risk Strategies company sponsored webinar. And so Risk Strategies is one of our vendors at ACOexhibithall.com. And we would encourage you to visit their booth on the ACO Exhibit Hall website, and you can connect with their team. Chuck Newton's information here is on the screen as well. And that is it for today. Thank you all for attending. I hope that you found today's presentation very informative and helpful. And one last thing is that the recording will be available following the presentation. You can give us a few hours at the ACO Exhibit Hall website in the library section. You can do a search for webinars there. So hope you all have a great rest of your day, and thank you for attending. Take care.